Welcome. Today we're diving deep into something truly fundamental. Constitutions. How they work, what they do.
Absolutely.
Our mission is to really get under the skin of constitutional law, especially by looking at how defined, codified systems elsewhere help us understand, well, the great legal outlier, the UK's unwritten setup.
Right.
The big puzzle we're tackling is, how does a system function when its most vital rules are, flexible, not written down in one place, and sometimes even seem to clash?
It's a fascinating puzzle because the UK Constitution isn't one neat document. It's more like a dynamic interplay, sometimes a collision, between core ideas.
Like what?
Well, you've got parliamentary sovereignty bumping up against the rule of law. You have this idea of separating powers, but in practice, they're quite blended. And then there are these powerful but non-legal things called conventions guiding how the state actually runs day to day.
Okay.
We really need to unpack how all these pieces fit together, or maybe don't fit together, to figure out where the legal authority truly lies.
Right. So to get a grip on the UK's, let's say, flexibility, maybe we should first look at what constitutional certainty looks like elsewhere.
Exactly. The global norm is a codified constitution. Most countries have one.
And these often come out of big historical moments, right? Revolutions, independence, a clean break.
Precisely. A constitutional moment forces a society to sit down and write the rules from scratch. It creates a single foundational document.
Okay, give us an example.
Well, think about Namibia. Its 1990 constitution is a direct response to a really tough history. German colony, then ruled by apartheid South Africa.
So the Constitution was about preventing that kind of unchecked power from ever happening again.
That's the heart of it. Article 1.6 flat out states the Constitution is the supreme law. No ambiguity.
Supreme law, meaning above Parliament, above the government.
Absolutely. And crucially, Article 131 legally entrenches fundamental rights. They're baked in, protected from easy changes by Parliament.
So you can't just pass a regular law to diminish those rights.
No. Amending the Constitution itself is deliberately difficult. It needs a supermajority in their legislature, maybe 2/3, sometimes even a referendum. It's built to be rigid, to protect citizens from the state.
Interesting. So Namibia designed its constitution to constrain the state. But what about a system where the Constitution seems more focused on organizing state power itself, like China?
Yeah, China's a really useful comparison here. The People's Republic Constitution, it's evolved a lot since 1949, reflecting all the political shifts.
How does it differ structurally?
Well, one key thing is it establishes a division of power, which isn't quite the same as the Western idea of separation of powers. And Article 1 is very clear. The leadership of the Communist Party is fundamental to the state.
Okay, so the party's role is constitutionally embedded.
Right. And this shapes how they view the rule of law. It's often described as rule by law. The Constitution sets up the state machinery, but it's not something the courts typically apply directly to challenge state actions. There's no judicial constitutional review in the way we might think of it.
So the law serves the state rather than constraining it in the same way as Namibia.
Essentially, yes. The state directs the law. These examples really show, that a constitution's job depends entirely on its context, history, politics, culture.
And the UK seems to have sidestepped that big constitutional moment decision.
It feels like it. It's more of an organic evolution over centuries. You can trace threads back to Magna Carta in 1215, but there was never that single revolutionary break leading to one document.
Which leads us to the core puzzle.
Exactly. Without that supreme document, where does ultimate legal authority, sovereignty, actually come from in the UK?
This is where it gets really interesting, isn't it?
Yeah.
How do you define the ultimate legal power without that single supreme text?
Right.
Where does the buck stop, legally speaking?
Well, we usually talk about it in two ways. There's political sovereignty, which arguably rests with the people, you, the electorate. You choose parliament.
Okay, the power of the ballot box.
But then there's legal sovereignty. And in the UK system, that power, the ultimate right to make or unmake any law, resides in the Crown and Parliament. Parliament is legally the top dog.
And the classic definition of this, the sort of benchmark, comes from Dicey, the Victorian scholar. What was his take?
Dicey nailed it down to two key points, or limbs, as they're often called. Simple but profound. First, Parliament can make or repeal any law it wants, on any subject.
No limits.
Legally speaking, no theoretical limits. And the second point, no other person or body, crucially, not the courts, can override or set aside Parliament's legislation. Parliament is legally supreme.
Okay, simple in theory. But how do the courts actually uphold that? Are there specific legal rules they follow to make sure Parliament stays supreme?
Yes, there are supporting doctrines. One is the enrolled bill rule. Once a bill passes Parliament and gets royal assent, becoming an act, the courts won't look behind it. They won't question how it was passed. That goes way back to cases like Warhope in 1842.
So the process is Parliament's business, the courts just accept the final act.
Pretty much. And the other key one addresses time. How does one parliament avoid tying the hands of the next one?
Right, you said Parliament can't bind its successors.
Exactly. That's upheld by the doctrine of implied repeal. If a new act conflicts with an older act, the new act automatically, implicitly repeals the conflicting bits of the old one. It ensures each parliament is sovereign in its own time.
Okay, so Parliament is supreme, unstoppable, cannot be questioned by courts, and can't tie its own hands for the future. Sounds pretty absolute.
That's the traditional Dicey view, yes. Very absolute.
But, and this feels like a big but,
Mm-hmm.
haven't the courts themselves started to, well, complicate this picture, especially with these so-called constitutional statutes?
Oh, yes. This is where things get really interesting in recent decades. It's a major development. The courts have identified certain acts of Parliament as being, well, more fundamental.
Like which ones?
Things like the Human Rights Act, 1998, the Devolution Act setting up Scotland's Parliament, and the Welsh Sended, the Constitutional Reform Act, 2005, which created the Supreme Court itself.
And what's special about them?
The courts have suggested these constitutional statutes are not subject to implied repeal in the normal way. Parliament can still appeal them, of course, it's sovereign, but it has to do so expressly, clearly, intentionally.
So it's like the courts are imposing a manner and form requirement, saying you can change these fundamental rules, Parliament, but you have to be absolutely explicit about it.
That's a good way of putting it. It suggests these statutes have a higher status, requiring Parliament to pause and think and state its intentions clearly if it wants to override them. It's definitely a shift away from the purest form of Dicey's theory.
A kind of judicially protected foundation.
Perhaps. It certainly shows the courts carving out a role in protecting certain fundamental aspects of the legal framework, even if those aspects were created by Parliament itself.
Okay, let's broaden out from sovereignty. What about other checks on power? The rule of law is a huge concept, but it's not neatly defined in one UK statute, is it?
No, it's not. It gets a mention in the Constitutional Reform Act 2005. Section 1 just says the act doesn't undermine it, but it doesn't define it. It relies heavily on judicial interpretation and, well, tradition.
So how do we understand it?
Well, Dicey had a fairly formal view. Nobody punishable except for breaching the law, everyone equal before the law, rights protected by common law. But modern thinking, like Lord Bingham's, goes much wider.
Wider how?
Bingham argued the law must be accessible, clear, predictable. Power should be used fairly, reasonably. Fundamental rights need protection. The state should comply with international law. It's a much more substantive vision.
And how is this rule of law actually enforced? What's the mechanism?
Primarily through judicial review. This is the key tool. It's where the courts scrutinize the actions of public bodies, government ministers, local councils, you name it, to make sure they're acting lawfully within the powers Parliament gave them. It's the courts policing the boundaries of executive power.
Keeping the government in check, essentially.
Exactly, making sure they don't act ultra vires beyond their powers.
This obviously connects to the separation of powers. But the UK's version is unique, right? Because the executive, the government, sits inside the legislature, Parliament.
It is unique. It's often called a fusion or blending of powers, not a strict separation like in the U.S. The government ministers are typically MPs or lords.
But judicial independence is still crucial.
Oh, absolutely vital. The Constitutional Reform Act 2005 put a huge emphasis on guaranteeing the independence of the judiciary. That separation is fiercely guarded.
Okay, what about those other powers, the ones that don't come from Parliament? The prerogative powers.
The royal prerogative. These are the sort of ancient residual powers left over from when the monarch used to run things directly. Now they're mostly exercised by government ministers in the crown's name.
Like making treaties, appointing the prime minister, dissolving Parliament.
Yes, things like that. Granting royal assent to bills is technically a prerogative power too, but there's a crucial limit, a really important one.
Which is?
The prerogative cannot be used to change domestic UK law. Only Parliament can do that. And Parliament can also override or abolish prerogative powers with legislation if it uses clear enough words.
So Parliament is still supreme over the prerogative.
Yes. But day to day, how these powers are used and how the whole system meshes together relies heavily on something else.
Constitutional conventions, the unwritten rules.
Exactly. These are non-legal rules, habits, practices, traditions, but they're considered binding on the people involved, the politicians, the monarch. They regulate how significant constitutional powers are actually exercised.
But crucially, non-legal, meaning you can't go to court to enforce them.
Correct. The courts generally won't touch them. Think of the big ones. The monarch always acts on ministerial advice, that's the Cardinal Convention. Royal assent is always given to bills passed by Parliament.
Even though technically the Queen could refuse.
Technically, perhaps, but the convention is ironclad. Then there's the Sewell Convention, the idea that the UK Parliament won't normally legislate on devolved matters for Scotland, Wales, or Northern Ireland without their consent. Politically vital, but not legally binding.
Okay, so we have this complex mix. Supreme Parliament, rule of law upheld by courts, prerogative powers limited by law and convention, and these non-legal conventions oiling the wheels.
Yeah, that's a good summary.
Which then raises the really big question. What happens when these principles seem to collide? When the executive, maybe using prerogative powers, clashes with Parliament's authority or the rule of law? That must be the ultimate stress test for this unwritten system.
It absolutely is, and that's precisely what brought us the two landmark Miller cases. These cases forced the Supreme Court to step in and draw some very clear lines in the constitutional sand.
And the fact they were heard by the maximum 11 justices, using special leapfrog appeals, tells you how significant they were seen to be.
Immense constitutional significance. These were urgent questions about the fundamental balance of power.
Okay, let's take Miller first, from 2017.
Yeah.
It's about Brexit, triggering Article 50. Could the government just use its prerogative power to notify the EU they were leaving?
That was the core issue. The government argued treaty making and leaving was a classic prerogative power, but the counterargument was, leaving the EU wouldn't just change international relations, it would fundamentally change UK domestic law. It would strip away rights people had under the European Communities Act 1972.
And the ECA 1972 was seen as one of those constitutional statutes.
Exactly. So the conflict was, can the executive use prerogative power to effectively nullify rights granted by a fundamental act of Parliament?
And the Supreme Court said.
They said no.
All right.
The court ruled that because withdrawal would inevitably change domestic law and destroy statutory rights, the government couldn't use the prerogative. It needed Parliament's explicit authorization through a new act of Parliament to trigger Article 50. The prerogative power for treaties just didn't stretch this far, given the unique nature of the EU and the ECA.
A huge assertion of parliamentary sovereignty over the prerogative.
Monumental. But interestingly, what did the court refuse to rule on?
The Sewell Convention. The consent from devolved legislatures.
Correct. They explicitly said Sewell was a political convention, important politically, but not legally enforceable by the courts. They upheld that distinction between law and convention.
Okay, so that sets the scene for the next clash. Miller II or Cherry in 2019. This was about prorogation suspending Parliament.
Yes. The Prime Minister advised the Queen to prorogue Parliament for 5 weeks in the run-up to the Brexit deadline. The question was that advice lawful? Could the courts even rule on it?
Could they?
The Supreme Court first decided unanimously that yes, it was justiciable. They weren't reviewing the political wisdom of prorogation, but the legal limits of the power itself. Did this specific exercise of the power go too far?
And their conclusion on whether it went too far.
Again, unanimous and explosive. The prorogation was ruled unlawful, null, and void, as if it had never happened.
Why? What was reasoning?
The court's reasoning was absolutely fundamental. They said prorogation is lawful only if it doesn't frustrate or prevent Parliament from carrying out its core constitutional functions without reasonable justification.
Its functions being?
Legislating and holding the government accountable. The court found that suspending Parliament for 5 weeks at such a critical time, with no good reason offered by the government, had exactly that effect. It improperly silenced Parliament.
So it undermined parliamentary sovereignty and accountability.
Precisely. The length and the timing, combined with the lack of any genuine justification, meant the advice given to the Queen was unlawful. The court essentially protected Parliament from the executive sitting within it.
Wow. So putting it all together, what do these Miller cases really tell us about the UK's unwritten constitution today?
They show the courts acting as the ultimate guardians of core constitutional principles, even unwritten ones. When Parliament and the executive clash, or when the executive seems to overstep, the judiciary will define the legal limits of power based on principles like parliamentary sovereignty and the rule of law.
So even without that single document, there are fundamental rules and the courts will enforce them.
That seems to be the clear message. The UK Constitution might be flexible and largely unwritten, but the Miller cases demonstrate it is certainly not toothless or undefended when fundamental principles are at stake.
Okay, so we've journeyed from the very clear, rigid frameworks of places like Namibia and China built for certainty to this incredibly fluid, convention-laced system in the UK, where it seems the courts have become crucial referees managing the tensions between a powerful executive and a legally supreme parliament.
I think that's right. And the key takeaway, perhaps, is that the UK Constitution, despite its ancient roots, is constantly evolving. It's been radically reshaped just in the last few decades by major statutes, the Human Rights Act, devolution, the Constitutional Reform Act.
So the flexibility is still its defining trait.
It seems to be. It's both its great strength, allowing adaptation, and, well, the source of endless debate and these kinds of constitutional stresses.
Which brings us to a final thought. The UK system centers legal sovereignty in Parliament. But political sovereignty, you said, rests with the people, the electorate. They choose the Parliament. This gives the people what's sometimes called constituent power, the ultimate power, perhaps even revolutionary, to create or replace a constitution.
The ultimate backstop.
Given the UK system's flexibility and the court's active role now in policing its boundaries, as we saw in Miller, how likely do you think it is that the people would ever feel the need to use that ultimate constituent power to force fundamental change? Is the system adaptable enough to avoid that? What stands out to you?